A very good evening to all the learners and very welcome back to the StudyIQ Judiciary channel. This is me Ishita and today we are doing part 2 of the Transfer of Property Act. In this session I will be deeply covering all the concepts along with your MCQs. Now these MCQs are your PYQs. So majorly they are PYQs of which are asked in all the states and various kind of entrance exams, of LLM entrance exams and of UG entrance exams as well. They are asked in your AIB and your AP also. So I have not specifically mentioned that where are they asked because this is a compilation of all the PYQs which are asked in the exams. Now, one surety and guarantee which I take of this session and all my continuing sessions is that these are the questions which will be coming in your exams, which have come in your exams, and this is my guarantee to make your concepts very clear in the first go. So before starting, I want you to all join to my Telegram channel. Like yesterday, many students were complaining that ma'am, we are not able to scan the code properly or the image was not visible properly. Now today your problem is fixed because I listened to whatever you students have feedback to give to me. Scan this code, join with me on my Telegram channel, ask your doubts, be it of any judicial services exams, be it of any entrance exams or anything law related, in general doubts, any subject specific doubt you want to ask. Join me on my Telegram channel right now. Scan this code. Okay, so now let us begin our session. Harshi Eco Infrastructure is saying hello ma'am, hello to you too. Now I want you to answer all the questions that you have joined this session. Okay, so let us begin. Question number 1. Very easy concept. Okay, let us read the question first. Under the Transfer of Property Act 1882, a contingent interest is created when an interest in property is to take effect. Now your option number A is forthwith upon transfer, only on the happening or non-happening of a specified uncertain event, only after registration, or option number D, in perpetuity. Answer the question now. I'll move a bit away from the screen so that you are able to read it properly and then I'll explain you the concept as well. Just give me 1 second, the board was not functioning properly. Just give me a second. Now, let us start. Okay, Harshi Eco Infrastructure, you are saying that answer is option number B. Yes, you are right, but let me first explain you the concept. So there are two types of interest when it comes to Transfer of Property Act. One is a vested interest and one is your contingent interest. So vested interest is given under section number 19 and your contingent interest is given under section number 21. Vested interest is that kind of interest in which you have 100% surety of the transfer of the property. Now one property which has been transferred, if it has been transferred in my name, now I have the 100% surety that it is in my name. I am the end owner of that property. But in contingent interest, it becomes a little bit conditional. It becomes upon happening of an event only. For example, if there is a match of India versus Pakistan, I promise to my friend B that I am A and I promise B that I will give you this property. If India versus Pakistan match may, if India wins, then this property will be transferred to you. Then if India wins this match, I will transfer this certain property to B. Okay, got it? So contingent interest is transferring of the property upon happening of some uncertain specified event. This event will happen, then only we will transfer this property. Okay, so I hope you got this concept. Let's move on to the next question. Next question is your question number 2. This question is, a contingent interest becomes a vested interest when. Now we learned just 2 seconds ago that what is vested interest. Any kind of specific interest from which there is a specificity, there is a certainty that this property has now been mentioned, this property has now been transferred to my name. So option number A. Now you got it, what is vested interest. Let's move on to the options. Option number A, the uncertainty becomes impossible or the event happens. The transfer is registered. The transferee takes possession. Or option number D, the transferor dies. Answer the question. Answer the question. I want everyone who is watching. Ratnakar Yadav, you are answering right. Hershey Eco, you are also answering right. Let us wait for 2 minutes for other students to also answer. Then I'll explain you the concept. Okay, so a contingent interest become vested interest. Which section talks about this thing? Section number 22. Now let me explain you with the illustration. For example, A transfer property to B, C and D. Now A says when this B, C and D, they will attain the age of 18 years, they will get the property. For example, C is the first one to attain the age of 18 years. So in this case, C will get the property first. Then B attains the age of 18 years at second number. Then B will get the property, and then D will get the property, and then B attains the age of 18 years at number 3. Matlab after a while. So then after C and D, B will get the property. Now here one important point is that it is not important that all three should attain the age of 18 years at the same time only. They can fulfill that contingency one by one. It is not important to fill that contingency at once. So that is why B, C and D, as and when they will attain the age of 18 years, they will get the property. That is why a contingent interest becomes vested interest when the uncertainty becomes impossible or the event happens. So now we can see the attaining of 18 years, which is our event. The attaining of 18 years, this event has happened. So the contingent interest will become your vested interest. Okay, let's move on to the next question. I hope you are able to understand. Just answer me in the comment section whether you are able to understand the explanations or you want me to even more simplify it for you. Question number 3. Section number 22 deals with the transfers to members of a class who attain a particular age. Such interest vests immediately, vests only in members who have attained that age, cannot be registered, is void. Answer this question. We can see that this question is a little bit similar with your previous question. This question is little bit similar with your previous question. So I hope that you are able to answer this. Everyone is answering B, and yes, you are absolutely right. We can befit the example of the previous question of A transferring property to B, C and D. And which sections does this talks about? This is section number 22. I have mentioned in the question also. Let us move forward. Question number 4. Under section 23, if a transfer is contingent on an uncertain event with no time limit, the interest fails unless it is registered within 1 year, the event occurs before or at the time the prior interest ceases. Option number C, the transferee signs an affidavit. Option number D, the transferor consents in writing. Answer this question. Question number 4. Now I have got an explanation for you for this section particularly. I have written it down in fact for you. So I would like to explain it to you. If A creates a life interest, I will write it life interest to B and then to C. The condition which has to be fulfilled by C is that if C completes his graduation, if C completes his graduation before the death of B, before death, if C completes his graduation before the death of B, then only C will get the property. But here, if B dies and C has not completed the graduation, then the property will automatically revert back to A. This is your explanation of section number 23, which says if a transfer is contingent on an uncertain event with no time limit, the interest fails. C is also not completing the graduation, B has also died, so the interest completely fails and the property will revert back to its original owner, because none of the person who is in the line B and C, they are fulfilling the conditions, they are not fulfilling the conditions. Okay, I hope you have understood it. Just write it in the chat box once whether you have understood or not. This was your question number 4. Hershey Eco, you have answered correctly. You have also answered correctly. The event occurs before or at the time the prior interest ceases. Okay, I just explained it to you. You both are correct. I'll move on to the next question, but first I need you to answer whether you have understood or not the explanation which I gave. Let's move on to question number 5. Question number 5 is your section number 24. Ma'am, issue with mic sometimes. Okay, let me just check the mic. I hope now you will not face the issue with the mic. Okay, let us move on to your question number 5, which is your section number 24 provides for transfers to such of certain persons as survive at an unspecified period. The surviving persons take joint tenancies, partition the property equally among survivor, or D, nothing. I will explain this to you with an example. Deepak Saroha has joined. Good evening, ma'am. Very good evening to you too. Answer this question which is visible on your screen. Answer this right now. Answer this question now. I will explain you. Ma'am, आपकी क्लास का टाइमिंग क्या है? My class starts at 5 p.m. every day live, and these classes are specifically in English. So if you are comfortable in English, then you are very welcome to join these sessions. And also there are many sessions which I have conducted in bilingual also, but I thought because the southern Indian state students and the northeastern state students, they face a little bit of difficulty in understanding Hindi language, so these sessions are specially for those students who have a little bit of difficulty in Hindi. Otherwise, other than that, majorly other students are very comfortable in understanding English, so anyone can tune in to these sessions. Telegram link I will just show you. Just keep on listening to the class first, and at the end I'll show you the Telegram channel again. Otherwise also it is mentioned in the description section also, so you can join my Telegram from there as well. Question number 5 on your screens now, and the answer is your option number C. The property equally divides among the survivors. Why? Because let us explain, let us understand with the example. A creates a life interest to B. Now when B dies, and just imagine that C also dies, okay? C also dies. So now in this case, the property which was to be divided among C and D. Now C will get the whole of the property, because when D has died, there is no need to give any kind of property to D. D has gone completely out of the picture. So now whole of the property which was to be divided between C and D, C will only get the whole of the property now. Otherwise, if D is alive, then C and D will equally get the property, will equally get the divided property amongst themselves. Okay, understood? Let's move on to question number 6. Your question number 6 is a transfer conditional on the performance of an act with no time specified is broken when the transferee fails to record the condition in writing, the act is permanently or indefinitely prevented, the transfer is unregistered, the transferor revokes. Answer this question. Question number 6. Question number 6. Hershey Eco, you are absolutely correct and you are first one to answer, so keep it up. Very good. The option is option number B, which is the correct option. The act is permanently or indefinitely prevented. Okay, so without any Ratnakar Yadav, you are also correct. Without any further delay, let us move on to the next question. And I just decided that I will show you the Bare Act also of some questions, which when we will move further, I'll show you the Bare Act also, so that even if you're not able to believe what the teacher is saying, you are able to believe the Bare Act, which is the Bible of law. So let us continue. Section 26 treats substantial compliance with the condition precedent as insufficient, equivalent to full compliance, voidable at the transferee's option, or D, grounds for recession. Very, very welcome. Question number 7. I think I should show you the Bare Act also. Wait. We are on question number 7. Question number 7, what was the question number 7? It was that section 26 treats substantial compliance with the condition precedent in. Now let us read the section. Okay, let us read the section. Section number 26 talks about fulfillment of condition precedent, where the terms of transfer of property impose a condition to be fulfilled before a person takes an interest in the property. The condition shall be deemed to have been fulfilled if it has been substantially complied with. If the condition has been already complied with, if some part of the condition has already been complied with, then it means that the condition which was required, it is already fulfilled. Chalo, let us read with an illustration also. A transfers rupees 5,000 to B on condition that he shall marry with the consent of C, D and E. Now E dies. B marries with consent of C and D. B is deemed to have fulfilled the conditions. Now here the example is A says with the A transfers 5,000 to B on condition that he shall marry on consent of C, D and E. Now in this case, one of C, D and E, one of them dies. Substantially complied, yes. One of C, D and E dies. So even if Mr. E dies and C and D have given their consent, so it will be deemed that Mr. E has also given his consent and now A can marry B. Okay, understood? Let's move on to the next question. I am showing you the Bare Act because I want you to truly believe whatever I have taken out from the Bare Act itself. Okay, it might take a little bit time for me to scroll and show you the actual sections, but this is the correct information. Okay, question number 8. Under section 27, an ulterior disposition in favor of a second person takes effect if the prior disposition, option number A, is registered, B, expires by efflux of time, option number C, fails regardless of manner of failure, your option number D, is enforced in court. Answer the question. Question number 8. Raghav Luthra has answered correctly. Your answer is option number C, fails regardless of manner of failure. Under section 27, an ulterior disposition in favor of second person takes effect if prior disposition fails regardless of manner of failure. Okay, let us move on to the next question. Question number 9. Section 35 on election requires an interested owner to, option number A, choose between confirming an unauthorized transfer or relinquishing the benefit conferred. Option number B, register their choice in the local registrar's office. Option number C, pay compensation to the transferee. Option number D, attend a court hearing. Answer this question. Question number 9. I hope you are able to see. I'll show you the illustration also. Ratnakar Yadav, everyone is answering correctly. Let me show you with an example. Okay, so this is the illustration of your section number 35. Is this visible on your screens? Just type yes in the comment section very fast. Just type yes. Give me a yes. A fast yes from everyone that whether this illustration is visible in the comment section or not. Then I'll proceed to explain it to you. The illustration says that the farm of Sultanpur is property of C. Okay, C has a particular farm in Sultanpur. What is the worth of that farm? It is of 800 rupees. Okay. A, by an instrument of gift, professes to transfer it to B, giving by the same instrument rupees 1000 to C. Now A comes and says, I will transfer your property to B, and Mr. C, you can keep 1000 rupees and your farm will get transferred to some other person. Now C elects to retain the farm. He forfeits the gift of 1000 rupees. Now C here says that I am very intelligent. I am not going to let go of my property. I want to keep my property also, and I want to keep the money also. Also, one point here is to be noted that C is getting 200 extra rupees of his farm. So C is now becoming very much over smart that I want to keep the money also and I want to keep the property also. No loss, no profit, only profit, and profit, a lot of profit. So this thing cannot be done. This is a fraudulent activity. What was the answer which you guys were answering in the comment section? Question number 9, the answer is option number A. Choose between confirming an unauthorized transfer or relinquishing the benefit conferred. So both things cannot happen at the same time. Okay, let us move forward. If you are liking this style of teaching, just let me know in the comment section first so that I can continue with this, or if you feel that a little bit time is getting wasted, you can let me know that as well. I'll try to change some other things. I will add some other things also. Just answer in the comment sections right now. Ratnakar Yadav, Raghav Luthra, Harshi Eco, everyone is very active in the comment section. I can see that, but just let me know this one thing also. Question number 10. Failure to elect within 1 year under section 35 leads to automatic recession, deemed confirmation of the transfer, voiding of the instrument, a new election period. Question number 10. Ratnakar Yadav is saying it's okay, it's completely fine. The answer for question number 10 is option number B. This option says that if you stay silent for 1 year, the law will presume that you have accepted what has happened. Okay? Raghav Luthra is saying yes ma'am, all good, very good bete. Chalo, let us come back now. Deemed confirmation of the transfer, option number B is your correct option. So now what was I explaining? If you stay silent for 1 year, the law will presume that you have said that you have presumed that you have given your confirmation, and that the law does not want people to delay whatever they have decided upon. So your silence will be deemed to be as the confirmation of your actions. Okay, let us move on to question number 11. Section 36 provides that periodical payments, rents, annuities, etc. accruing day to day upon transfer are A. non-apportionable, B. apportionable as between transferor and transferee, option number C. payable in advance only, option number D. void if unregistered. Answer the question number 11. Ritika Bhargav, you have joined a bit late, but I want you to answer the questions now continuously. Question number 11. Question number 11 was talking about section number 36, and the section number 36 talks about apportionment of periodical payments, determination of interest of person entitled. Here this section says that in the absence of a contract or local usage to the contrary, all rent, annuities, pension, dividends and other periodical payments in the nature of income shall, upon the transfer of the interest of person entitled to receive such payments, be deemed as between transferor and the transferee to accrue due from day to day and to be apportionable accordingly, but to be payable on the days appointed for the payment thereof. I hope I have read the section now, and Deepak Suroi saying ma'am aapki English achhi hai. Thank you so much. Thank you so much. I hope now that I read the section for you, I have shown you the section, what section 36 talks about. You are able to understand what is actually going on here. Okay, let us move on to next question. Your next question is question number 12. Under section 37, when an obligations benefit passes to several owners, the duty is performed, and your options are by the original obligor only, option number B, proportionately to each owner's share unless severance is impracticable, option number C, entirely by the owner with the largest share, option number D, upon registration of new interest. Answer question number 12 now. Question number 12. Jaldi, fast. Answer the question. Question number 12, your correct answer will be option number B, proportionately to each owner's share unless severance is impracticable. Okay, Ratnakar Yadav, you are correct. Deepak Suroha, you are also correct. Let us move forward now without wasting any further more time. Section 38 validates a transfer by a person authorized only under variable circumstances if the transferee, option number A, registers within 90 days, option number B, acts in good faith after reasonable inquiry, option number C, obtains a court decree, option number D, pays a statutory fee. Answer the question. Question number 13 on your screens right now. I'll explain you this section also. Section number, wait. Just a second. ये कौन सा होगा? Okay. I'm really apologetic to all the students. There was a little bit technical glitch, but it's okay. Now we can continue with the session. So we were on question number 13, section number 38 validates a transfer by a person authorized only under variable circumstances. Chalo, let us move forward. What was this question talking about? This question was talking about section number 38. Okay, so section number 38 पर चलते हैं. Section number 38, I'll explain you with the help of the illustration. A Hindu widow whose husband has left collateral heirs alleging that the property held by her as such is insufficient for her maintenance. So now there is a person, there is a Hindu widow woman. Now whichever property is being held by her husband, that property is insufficient for her survival. That property is insufficient for her survival. She cannot maintain upon the whatever income she is accruing from that property. So now what happens? Agrees for purpose neither religious nor charitable to sell a field part of such property to B. B satisfy himself by reasonable inquiry that income of the property is insufficient for A's maintenance and that the sale of the field is necessary, acting in good faith buys the field from A. So now B here enters into the picture and now B here buys the property from A, given the fact that this property is insufficient for her survival. So now whatever act which B has done after reasonable due care. B has done this act under good faith. Now as between B on one part and A and the collateral heirs on the other part, a necessity for the sale shall be deemed to have existed. Okay, because there was a necessity, that is why this action was taken. Okay, so what is the correct answer for question number 13? Question number 13, your correct answer will be option number B. Option number B. Okay, let us move forward. Question number 14. Under section 41, a transfer by an ostensible owner is upheld if the transferee, option number A, registers the deed immediately, has no notice of the transferor's lack of title, uses property for commercial purposes, option number D, acts in good faith after reasonable care. Answer this question, question number 14. Students are very understandable here. They were able to understand. There was a little bit of technical glitch, but we are back on track. We are back with the session. Now I want you to be very active in the comment section. Answer this question. Question number 14 on your screens. Question number 14. Ratnakar Yadav is saying 14 option number D. Ratnakar Yadav, you are absolutely correct. Acts done in good faith after reasonable care, because I have written down the principle for you. Law protects honest buyer. For example, let us assume that you have bought a property from someone whom you think is the original owner of the property, but that turns out to be false in the future. But you have done your research, you have taken due and reasonable care, you have bought the property in good faith. So now here in this situation, law will protect the honest buyers, law protects the people who are honest, okay, and your purchase will be deemed to be considered absolutely valid, okay. Let us move forward. Question number 16. A transfer made with intent to defeat creditors is void ab initio, voidable at the creditors option, enforceable if registered, valid against subsequent transferees. Answer this question. Question number 16. The correct answer is, ma'am, AIB exam batch में आप भी हो क्या? Deepak Saroha, I am not sure of this information as of now, but you can tune into my sessions. I'm doing all my sessions here, and I'll show you my Telegram link also. Whatever doubt you want to ask, you can join there and you can ask me your doubts. Okay, now let us go. Let us move forward. This whole concept is covered under section number 53, and the correct answer for your question number 16 would be your option number B. What does this option says? This option says voidable at the creditors option. A transfer made with intent to defeat the creditors is voidable at the creditors option. Where is this concept covered? It is covered under section number 53. Okay, let us move forward. Section number 53 clause 2 treats a gratuitous transfer intended to defraud a subsequent transferees as avoidable at the transferees option, void ab initio, automatically registered, transforming into a lease. Answer. Question number 17. Question number 17, the correct answer is your option number A. It is voidable at the, very good. Ratnakar Yadav, you are absolutely correct. Yashwant, you are also correct. Question number 17, your answer is option number A, voidable at the transferees option, because if someone tries to defraud the subsequent buyer, what this question says, treats a gratuitous transfer intended to defraud a subsequent transferee, then that will be voidable at the transferees option. Let us move on to question number 18. Under section 53 clause A, part performance. Section 53 clause A talks about a part performance. I am writing the sections and I am writing their concepts also alongside them. The transferor cannot enforce rights against a transferee who has done nothing in furtherance of the contract, taken or continued possession in part performance, registered but not paid consideration, or option number D, given verbal assurance only. Question number 18, answer right now. Question number 18. Deepak Saroha, you are saying option number A. I am so sorry, students, you are not right this time. Question number 18, your correct answer would be option number B, taken or continued possession in part performance. Why? Because equity protects the honest. Law of equity says that it will protect the honest person. Why? I will tell you the reason why. The reason is that when for example, Thank you so much, Deepak Saroha. Your appreciation means a lot. But now let us focus on the session. So, understand this point. For example, you bought a house, or for example, you bought a rented place. You have moved to a different city, you have moved for your education, you have moved for a job, or anything else. You have bought a rented accommodation for yourself. Now, here let's say you have paid the rent, you have paid the security also, but because of some reason you have not got your rent agreement. So now in this case you have done your job, whatever you have to do, you had paid the rent, you had paid the security, you have done all the obligations which you had to do. So now in this case, even if you have not got the rent agreement, you will not be considered to be a person who has defrauded someone. You will be protected by the concept of equity because you are honest in this case. So this is what section number 53 clause a part performance talks about. You have completed your part performance. Now the getting of the agreement. Okay, ma'am, confused with language of question. It's completely all right. Here we are talking about part performance. We are talking about section number 53A, because when you have completed your part performance and the full performance of the contract is left to be completed from some other party to the contract, then when you have done your obligation, when you have fulfilled your conditions, your work is completed. You have done everything which you could do. Now you have to stop then and there only. Now the other party will fulfill their obligations whichever they have to fulfill. Okay, why? What is the reason why? Because law protects the honest. You are honest person, you have paid your rent, you have paid your security, now law will protect you. Okay, I hope Ratnagar Yadav now you have understood. Let us move on to question number 19, second last question of our session. Section 54 requires registration of a sale of tangible immovable property worth any value 100 or more, less than 100 only if sold to a non-resident. Now this question is very important. Why? Because this is a PYQ which I have seen is not only asked in one state but approximately 5 to 6 states consecutively. This is asked. This is a very you can think of this question as the most favorite PYQ of the paper setters. Okay, question number 19. I'll show you on the Bare Act also. We were talking about section number 54. Under section number 54, under the option sale how made, now come to this line. In the case of tangible immovable property of less than 100 rupees, such transfer may be made either by registered instrument or by delivery of the property. Okay. Now another point, delivery of tangible immovable property takes when the seller places the buyer or such person as he directs in the possession of the property. So now we were on question number 19. What would be the answer? Section number 54. Ratnakar Yadav, you are absolutely correct. Yashwant, you are also absolutely correct. Option number B. Just a second. Option number B. Rupees 100 or more. Let us move on to the next question. Under section 56, marshalling, if one of multiple mortgage properties is sold, a subsequent purchaser may require the mortgage debt to be satisfied out of the sold property first, the other unsold properties, any one property chosen by the mortgagee, court appointed trustee. Question number 20. I have given you a hint also. Question number 20. What does question number 20 says? If one of multiple mortgage property is sold, a subsequent purchaser may require the mortgage debt to be satisfied out of other unsold properties. Students, you are not right in this. You are incorrect. Yashwant, you are saying option number A, the sold property first. No, because whatever the worth, because whatever the properties will be left, the debt will be recovered, the debt will be recovered, the debt will be satisfied from those remaining properties only. That is why other unsold properties. Option number C is incorrect. Any one property chosen by the mortgagee, no. You just have to cover that debt. You just have to take out whatever mortgage money is left. Okay. So in order to cover that debt, only any other property, any other unsold property can be used. Okay. It cannot be specified by the mortgagee. Yes. Option number B is correct. It is not the responsibility of the mortgagee to choose whatever property they want to sell and get the property worth recovered from that. That is why option number B will be correct. Other unsold property. Now, who was the student? Deepak Saroha. You were asking for the Telegram channel link. Wait, I'll show you. Students, this was the end of this session, and Deepak Saroha, like you were asking for the Telegram channel link, you can click a screenshot of this session, and this is my Telegram channel link. You can join with me there. I conduct these sessions daily at 5 p.m. only on StudyIQ Judiciary channel, and my name is, as you might know, my name is Ishita, and right now we are covering TPA Act, and as we move forward, we will be covering other acts also. If you like my teaching style, or if you want to give any kind of inputs, you want me to add something, you want me to like how we conducted the sessions today, you want me to show the bare act accordingly as and when we move with the sections, tell me anything, tell me everything in the comment section. Join with me on Telegram channel and tell me there also. Ask your doubts, be it of any subject, be it of any entrance exam also. Thank you so much, students. Your appreciation means a lot, and your appreciation is my motivation to conduct even more interesting sessions for you. It gives me motivations to even work hard for you, because you are the people who are asking me the doubts, and I am here to solve each and every doubt for you. Thank you so much. So that was it for this session. Thank you.